Hello, everyone, and welcome to another edition of MHQ's Foundation 101 podcast, 26th edition, would you believe? And today we are talking about a topic which I actually thought would never come, but so here we are. We are talking about a UAE Mainland Trust Law. So why does it matter? Is that for the past couple of years, we've literally seen Islamic legacy planning revolution take place in the Gulf. And before that period, it was quite literally a desert here in terms of tools available. We didn't have much. We were handling pretty much everything with contracts and companies. But then, lo and behold, came the DIFC, ADGM, both introduced trust laws as part of their framework. And later on, both together with Ras Al Khaimah, introduced foundation regime in their offering. So today, within these free zones, we end up with having all the modern tools that one would expect from a tier one financial center, tier one structuring center that the UAE has become on the worldwide scene. But there was one piece missing, which was, do we actually need UAE mainland trust law, and this piece of law has now been introduced, and David Russell, that is joining us this morning, was the one in charge of ensuring that its English translation and content is actually appropriate. David, good morning.
Good morning, Jan.
And you are a returning guest on this webcast. And today we're going to look into this law, its key features, and how it stacks up with all these other tools that we have, because it's a real supermarket of legacy planning and asset protection tool today. So let's help our listeners to navigate this offering. My first question to you will be a UAE mainland trust law. What is it?
Well, the UAE could have addressed the question of the operation of trusts in one of two ways. It could have become a party to the Hague Convention, which is an international convention for the recognition of trusts, and then relied on trusts to be established in the financial free zones or other jurisdictions and operate within the UAE. And that, in many ways, would have been the simplest way of doing things. In Switzerland, for example, and for that matter, in Italy, they've proceeded by way, and the Netherlands, they've proceeded by way of the recognition, signing the Hague Convention. The more difficult task, which is what the UAE government has undertaken, is to create an indigenous trust law, and to do that operating within a framework of civil law. And that is a complex process, because the basic proposition in civil law is that everything has to be written down. You can't have rights in relation to property in particular that aren't recognized by law. And so in civil law jurisdictions, traditionally, trusts have not been recognized. And the UAE trust law seeks to address that problem within the framework of the UAE legal system. But it has the additional result that whereas before there may have been some doubt as to whether or not trusts were consistent with the underlying legal principles of the country, or public order, to use the civil law term.
Yes.
That is now resolved, because clearly if trusts are permissible and can be established under UAE law, and there's express provision for the operation of foreign trusts under this law, it necessarily follows that there's nothing inconsistent with trust jurisprudence generally, and the UAE trust law, or the operation of laws generally in the UAE. So it's revolutionary in that sense, and a very important part of the country's legal development, as you said, Jan, to becoming a centre for wealth management in the world. And I read in statistics from Reuters that came out just last week, the UAE is now recognised as the 10th largest jurisdiction in the world. So things are moving forward, and at a very great pace.
So if it was such a hard work, and as you said, it's rather complex to introduce a trust law in what is a civil law regime, for whom is it? Who did the legislator have in mind when introducing this law, given the fact that there were already existing laws in the DIFC and EDGM?
I think from my discussions, the areas of particular interest were local families who may have been uncomfortable with using foreign trusts in the context of the UAE, or for that matter, using financial free zone trusts. Any lack of confidence they might have had on the basis that they might not be enforced on shore is resolved by this law. The second area of interest is families in the UAE who've used structures outside the UAE for their foreign assets. This law, of course, applies to assets anywhere, so that there's capacity for redomiciliation. And that is a very real issue for a lot of UAE families because privacy has a particularly high cultural value here.
Yes.
And it's essentially being destroyed in Europe, the Crown dependencies and the British overseas territories. So you'll find a lot of families whose, if their choice is to redomicile their structures to the UAE or to find out about their family assets in the newspaper, which will be the implication of some of the changes that are being made in Europe, they will choose to redomicile. And there's finally the point that the UAE has a lot of judicial cooperation treaties with other countries in the Islamic world, particularly the Riyadh Arab Convention. This law can be used, coupled with those conventions, to make this a centre for wealth planning for regional families, not just in the UAE.
So it would not be an MHQ webcast if we didn't have a nice comparison chart illustrating all these changes. But before we jump into that, can you maybe point out some of the key features that you see in this new law that people should remember as a first pop-up?
Reading it, it's in many ways apart from what I might loosely call the interface provisions, which make sure that it fits into the civil law concepts of the UAE, it's very much a traditional trust law. It contains the full definitions of the responsibilities of trustees, the rights of beneficiaries, the obligations of the settlor, whether or not there can be reserved powers, protectors, the role of the courts. There's very little in there that would not be familiar to a conventional common law trust lawyer. The two things that are dramatically different are the requirement of registration as a condition of validity, and the requirement, at least in the UAE, that assets be specified as part of that register. The other practical point is that this will be administered by civil law courts who have no experience in trust jurisprudence. One of the issues, as we discussed in our last podcast with the DIFC, was concern of uncertainty as to what the DIFC courts would do in their role as administrators of the trust. That was something I never had any doubt about, but it doesn't change the fact that there was a level of reluctance in the region to accept that the DIFC courts would just act as a conventional common law court. But you might expect much the same concern to arise, given that the civil law judges won't have had any experience in connection with the administration of trusts, nor in the civil law court context is the doctrine of precedent applied as rigorously as it is in an English court.
Yes.
So there will be an issue about how long it takes the level of certainty to develop in the civil law courts. That will be expected.
And we have seen it with foundation the same way. Yeah, we've seen first 2 years people were really dipping their feet, and now 75% of foundations in the Middle East were registered last year. So it's a small wave that became a tsunami, and it is likely to become the same thing with the use of UAE Mainland Trust Law, where people gain confidence and start to use the tool. So here is to rebound on a couple of points you put forward. As we mentioned, the DIFC and EDGM are common law frameworks with courts applying common law. But in the UAE mainland, it's completely different. It will be the local civil courts which will administer any matters relating to this trust law. So a completely new thing for them. Likely a role to play for you, David, there educating the judiciary. So that will be fun. The other item, which I know is dear to your heart in terms of privacy, is that we know that the DIFC has made available an arbitration clause for a family dispute as part of the trust and foundation laws. We do not know yet what the future lies in terms of UAE mainland trust law as well as ADGM, but the hope is that in due course, this becomes a reality for family in the UAE mainland as well, to be able to choose their forum and how they wish to solve dispute. This tags with the privacy aspect, because in a trust arrangement in ADGM or DIFC, everything is private. Yes, the regulator can have some oversight and understand what the assets are, of course, the source of funds, source of wealth. But in the UAE mainland is a little bit more administrative. The registrar is not public and won't be. This is essential. But there must be a registration of the trust, which is a key difference with what you see in ADGM and DIFC. And you must have an asset ledger documenting exactly which documents are part of the trust and those that aren't. This is important because, of course, we still live in a Muslim country, and in terms of potential probate, you want to make it clear which assets is outside and which one isn't. The other point that I would love your feedback. Yeah, go ahead.
While we've got that issue highlighted, one of the consequences of the requirement of registration of an asset of assets in the asset ledger is that it means that you won't be able to conduct business through the trust.
Yes.
Because in the nature of any business, assets keep turning over all the time. So you will need, and you deal with this at a later point in the slideshow, you will need often to have a corporate vehicle under the trust so that the relevant trust asset shares in the company, rather than, for example, ownership of a building or something of that sort. Because otherwise, every time you change anything, you will need to change the asset ledger. And if, for example, you are running a shop, the assets that you have on hand at any given time change, and hopefully change very regularly.
Yeah.
So it will dictate the type of structure that has to operate under the trust as well.
Yeah, good point. And the other point that I think is very interesting, and that may evolve over time, but at least that's a starting point, is that one needs to retain a professional trustee or an institution, which, as far as we know, do not exist much, or at least there's not that many people that would know how to do that. You would expect local banks to jump on the bandwagon and offer that service eventually. But in the ADGM and DIFC, this is much more flexible. We've seen this recent judgment from the DIFC High Court, which confirmed that a foundation, for example, can act as a private trustee to a trust, no problem at all. I would expect the same thing in the ADGM. So their families can have much more control, much more flexibility as to the arrangement they wish to put in place. Whereas in the UAE mainland, initially at least, they will have to rely on a third party, which is something interesting.
There's a slight qualification to that.
Mm-hmm.
That's certainly so if you want to use a corporate trustee, because only a licensed professional trustee company can be a corporate. As a corporation can be a trustee.
Yep.
Individuals can be trustees, but that's a very complicated situation, and it would normally not be the advice you would give someone to have individuals as trustees. So what you say in practical terms is correct, although legally it's technically possible to have individuals only as trustees and not involve a professional trustee company.
And if that was the case, then you have the importance of the asset ledger, because if, let's say, a patriarch is to act as trustee for his family, then it is paramount that the assets he has as part of his own P&L and those that he holds as part of a trust arrangement are clearly segregated, so that it does not become very messy in terms of probate. To me, the most interesting part, of course, is the practice. And here we have the compatibility with, first with UAE assets, with different asset classes, and with the assets location. Could be in the UAE, could be outside. We can see it here. All the provisions pretty much provide that there is no limitation geographically. So this is good news. But that if you look at the mainland trust regime, the hope is that it becomes very easily over time compatible with UAE real estate. We know that the UAE trust, the DIFC and ADGM trust regime have struggled to be accepted by the land department in both Dubai and Abu Dhabi. It's, to me, pretty much a question of education about the tool. It took foundation not as long to be accepted, and now both the Abu Dhabi and Dubai land department accept them without any issues. But the question is, how fast will UAE Mainland Trust be able to be accepted by the land department? Do you have any input on that, David?
Well, I think the Lands Department is going to have the same issue with the UAE Mainland Trusts as it has with the DIFC and ADGM trusts. And that is, how do you guarantee local ownership laws are maintained? You'll be aware that most of the land in the UAE is required to be held by UAE nationals or GCC nationals. And if there isn't a guarantee that that will happen, first, you may have a problem with local ownership laws. The other point in Dubai is if you're transferring to a trust whose beneficiaries are not exclusively family members, the Dubai Lands Department will want to collect 4% tax instead of the 0.25% transfer tax. So it becomes very important that you have a trust structure that satisfies the department in both those respects. There is a capacity to deal with that in the context of the DIFC, because the DIFC trust law specifically provides that you can have irrevocable provisions that exclude particular types of people from the trust beneficiaries, and you have a process of certification available through the registrar of companies. That is not available. Neither of those things is available in the ADGM. If one reads the mainland law, once you have a trust that's a mainland trust, then the registrars are supposed to accept it. But I think the registrars at the moment take the view that their role is discretionary. So yes, you're quite right. It will be a process of education, but also a process of making sure that the integrity of the local revenue arrangements and the land ownership requirements is not disturbed by these structures. Yeah. Because if they become a means of either avoiding tax or avoiding local ownership laws, you would expect pushback, and a fairly fast pushback from the authorities.
And understandably so, and we can see it with Foundation now. They are the vetting process is quite high, which is good, because it is important that the regulator have a good understanding of what these foundations do. And more importantly, whenever you have a change of beneficiary, it needs to be announced. Otherwise, you risk penalties and ultimately the registration. So I would expect the same sort of mechanism to be implemented in due course with respect to mainland trusts. So what you see here effectively is a menu, and we have added a new dish to the menu. And now the beauty is that families have the choice. Typically, regional families that have assets here, they can choose of using a mainland trust if they so wish. They could imagine setting up a foundation for similar purposes. One key aspect will be, do I want to segregate the jurisdiction where the asset is held from the jurisdiction where the asset holder is registered? This is often something people want to do. They may also wants to consider which court they want to rule on any potential dispute or interpretation. If they speak Arabic, that then they may have a preference for local court, perhaps. If they don't, chances are they will favor the AFC or the ADGM court, which have very efficient, very modern infrastructures and qualified English-speaking judges. The other point is whether you rely on a professional trustee or whether you do it yourself. Because what we see in foundations is the ability for families to take control. So who owns? In one case, is the trustee. In the other case, it's the foundation per se, and who controls? Here is the trustee, here is the council in the foundation, sometimes under the oversight of the guardian or the founder if they have reserved powers. But it's also a question of responsibilities. We often talk about responsibility of directors. If a family member is a council member in a foundation, they have a responsibility, but so will the trustee in a mainland trust. So again, the options are here. And if we were to look at a family which has done some of the homework so far in, for example, here, consolidating a pool of real estate under, say, a UAE mainland structure held by patriarch, this is as good as you could push it probably 2-3 years ago. Now you would have the option of setting up a mainland trust that would take over the shares in this family holding, as you mentioned, David. The patriarch could be the settlor, he could be the beneficiary. One could certainly imagine that he's granted substantial delegation powers over the underlying assets, within reason, of course. That is one way of sorting this issue, ensuring business continuity, preventing probate, ensuring asset protection. The other way is the one we have been discussing on this podcast for a long time now. A foundation registered in any of the centers here. Typically, if you have Dubai real estate, it would probably likely be a DAFC one. Foundation holding shares into this LLC, simple to do, and the family can have substantial control, not only by way of delegation, but also by sitting on the council as members. So the options are there, and the answer for most people would be take advice. Get educated. There's tons of people like David and I out there that are able to advise families on the differences on these tools, what the family's objectives are, short-term, long-term, and which tools meets your criteria. And it would be unlikely that we cannot find something that suits your taste out of this menu of tools introduced of late by the UAE. On this note, David, do you have anything to add on the topic?
Yes, I'd make one point that because the trust law, the mainland trust law follows basically the principles of the DIFC trust law. The ADGM trust law is basically English trust law.
Yes.
So a lot of it is not written down in a formal sense in the way the DIFC trust law is. But often you find local families don't really feel comfortable with concepts that can only be explained in English. And one of the great advantages of the mainland trust law is they can find out about a trust by reading the mainland trust law in their own language.
Yeah.
And the same to an extent applies with foundations, because you have the mainland equivalent of the foundation, which is an endowment established under the National Endowments Law. Or for that matter, there are endowments laws in both Sharjah and Dubai. So that even if ultimately the choice is made to use one of the English language jurisdictions, basic explanations and concepts for families are available in Arabic and in an official way.
Yeah. And yeah, that's a very welcome addition, because 15 years ago when I arrived here, we didn't have half of the laws in English. So you see, progress. So on this note, thanks you very much, David, for jumping here. I know you have a series of other interventions shortly to educate people about this new tool, and we'll be in touch soon to discuss how it works in practice, maybe to take stock in a couple of months on how this is going. David, thank you very much. Good day ahead.
Thank you very much, Jan. Good day.